My name is Bill Pearlstein. Let's switch from Nazi-looted art to antiquities, which present different issues. I don't have any pictures. It's beyond my technical capabilities. I'll try to keep it interesting. Most artifact-rich source nations nationalize every cultural object in their borders, in or out of the ground. These patrimony laws generally create constructive ownership and theft by statute and not by taking from an owner's physical possession. To me, the fundamental question with antiquities is whether U.S. federal and state courts should be in the business of enforcing foreign cultural patrimony laws. U.S. legal scholars first considered this issue at the 1970 UNESCO Convention in Paris. Contrary to popular belief, UNESCO does not contemplate universal national retention or automatic restitution. Instead, it focuses on national retention of a subset of objects important to national heritage while allowing private ownership and export trade. Even so, the U.S. delegation had fundamental reservations. They would not let the United States hand a blank check to foreign nations by automatically enforcing all-inclusive patrimony laws. In 1983, Congress implemented UNESCO by passing the Convention on Cultural Property Implementation Act. The act limits the forfeiture of stolen property to theft from possession, not by decree. U.S. import restrictions are finite and selective. They're limited to culturally significant objects and conditioned on findings of self-help, concerted international response, mitigation, international exchange. Repose is conferred on objects that have been exhibited by U.S. museums or long held by private collectors. Senator Moynihan, the primary sponsor, intended the Implementation Act to be our definitive national policy regarding the importation of archaeological and ethnological materials, balancing the competing interests of archaeologists, dealers, source nations, museums, state and justice departments, and customs. Tough balancing act. Yet, while Congress was deciding not to hand foreign nations a blank check, U.S. federal courts were handing it back. Under the late 70s McLean cases, criminal liability under the National Stolen Property Act can arise if a U.S. holder knows that an object was exported in violation of a foreign ownership law. McLean was opposed at the time by museum and dealer groups and criticized by Professor Paul Bator, head of the U.S. delegation to UNESCO and still the leading scholar in the field. He said, "The case erodes the distinction between stolen and illegally exported antiquities in a disturbing way. A blanket legislative declaration of state ownership of all antiquities, discovered and undiscovered, is an abstraction. Yet McLean gives this abstraction dramatic weight. Illegal export is elevated to theft. The exporting country, without affecting any changes at home, can invoke the criminal laws of the United States to help enforce its export rules by simply waving a magic wand and promulgating a metaphysical declaration of ownership." In 1985, Senator Moynihan proposed a bill that would have limited the Stolen Property Act to antiquities stolen from possession and not by decree. Professor Bator testified that the Implementation Act was designed to deal with the problem of archaeological looting and should control. General American criminal law should not be artificially manipulated to deal with the theft of unprovenanced artifacts. But state and justice opposed the bill on grounds of enforcement and diplomatic expediency, and the bill failed. In consequence, criminal liability can be triggered by imports permitted by the Implementation Act. The courts did not consider this tension until 2003, when the Second Circuit affirmed the conviction of Fred Schultz for conspiring to receive objects smuggled from Egypt. And at that time, Larry was representing or co-counsel to Egypt, and I represented a dealers association, or a bunch of groups, on the Second Circuit amicus brief. The District Court and the Court of Appeals considered the potential overlap between the two statutes and noted that bad acts can trigger overlapping remedies under civil and criminal law. But the District Court concluded, strangely I think, with all respect to Judge Rakoff, that the Implementation Act was not intended to deter theft, which is an interesting commentary in light of the legislative history. And both courts failed to recognize that McLean criminalizes trade that the Implementation Act was designed to promote. The Schultz courts could have concluded that as a matter of statutory construction, the Stolen Property Act should apply only to antiquities stolen from possession and not by decree, which the facts might have warranted. They could have gotten the bad guy. Instead, the Second Circuit affirmed on a broad theory of constructive state ownership. McLean ought to be conformed to the Implementation Act either by statute or judicial construction, or principles of comity should govern a federal or state court's decision whether to enforce a foreign ownership law. The test would be whether enforcement is consistent with U.S. policy as articulated in the Implementation Act, including findings of self-help, mitigation, and international exchange. That would be a more thoughtful approach than the rule of McLean, which tests only whether the defendant knew about a foreign ownership claim without testing the threshold question of whether, as a matter of public policy, a U.S. court should be in the business of enforcing the foreign law. The federal court's application of general criminal law to the complex issues presented by the international antiquities trade is at odds with congressional policy and, I think, the better thinking on the issue. I hope that the federal and state courts will eventually revisit the issue and bridge the gap. Thanks very much.